What's that?
Today is Tuesday, November 8, 2022. This is another day of trial in State of Ohio plaintiff versus George Wagner IV defendant. Case number 2018 CR 155. The defendant is present in court with attorney John Parker and attorney Richard Nash. The State of Ohio is represented by prosecuting attorney Ron Jones and special prosecuting attorneys Angela Canepa and Andrew Wilson. Also present is Brian Scheider, special agent for Ohio BCI-9. Yesterday, when we adjourned for the day, Agent Scheider was on the witness stand, and the state had concluded, I believe, its direct examination of Agent Scheider. It was time for the defense to be given an opportunity to cross-examine. Is the state ready to proceed to bring the jury up, of course, but ready to proceed today?
Yes, sir.
Is the defense ready?
Yes, sir.
All right, we can bring the jury up and have Mr. Scheider Agent Scheider take the witness stand as soon as we get the jury seated. You may be seated. Good morning, ladies and gentlemen. It's good to see you all here. You'll recall that yesterday, at the end of the day, that Agent Scheider was in the witness chair, and the state of Ohio had concluded its direct examination of Agent Scheider, and it was now then the opportunity of the defense to conduct cross-examination. So, Agent Scheider, if you'll go ahead and occupy the witness chair. I would just simply remind you that this is continuous testimony, so that the oath that was administered yesterday is still in effect. You're still under oath to tell you.
Understood, Your Honor.
Is the state ready to proceed today?
Yes, Your Honor.
Is the defense ready?
Yes.
Or you may commence your cross-examination.
Thank you. Good morning, sir. How are you?
Good morning.
Good to see you again. Just a few questions, sir. Do you have the exhibits for us? Okay, sir, I want to ask you a few questions about your testimony yesterday. You testified about taking some photographs of the truck that was recovered in Athens County, correct?
Yes,
All right, and you found a couple volunteers, I think you called it, to crawl in the back of the space and take additional photographs, is that right?
correct.
All right, I want to ask you some questions about that if I could. When did you take those photos?
Last Thursday, Wednesday or Thursday, last
So-
week.
That would have been November. Do you remember the date? I don't have a calendar.
I don't remember the date
It
either.
was certainly after Jake testified, would you agree?
Yes,
And it was a year and a half roughly after you had retrieved the truck from Athens County?
yes,
All right. And you took part in his proffer back in April of last year, correct?
yes,
And that was over a 2-day period, right?
yes.
12 to 14 hours roughly?
I believe it was 12 hours, yes.
Okay, and you certainly did not take those photos before he got the tremendous plea bargain he got, is that right?
I did not take them before the proffer, correct?
Or before the plea?
Correct,
You took them last week.
correct.
Right. Showing you what's previously been marked as quadruple B11. Will this be projected?
I can't project anymore.
Okay. Showing you what you identified yesterday as quadruple B11. Can you just briefly identify that and hold it up for the jury?
This would be a photograph of the rear of the vehicle, the murder vehicle, the truck that was seized from Athens County, documenting the license plate and the space created in the bed with the false bed installed.
All right. With this photo and the ones we're going to show that are labeled quadruple B, you never showed these to Jake, did you?
No,
And you certainly didn't take a video of any of this activity that was conducted last week, is that right?
correct.
And do you know if the tires on this vehicle are the same size as they were in April of 2016?
No, I do not.
You testified that these two volunteers got into the back of that truck, is that right?
The bed of the truck,
I'm sorry,
correct.
the bed of the truck underneath the plywood, right?
Yes,
Okay. And then at some point you put the tailgate up to show that they would fit inside, right?
correct.
All right. Did you leave that tailgate up for 20 minutes?
No, I did not.
Did you leave it up for 30 minutes?
No,
Did you leave it up for 60 minutes?
no,
Did you start the truck and let it run for 10 minutes,
no,
20 minutes?
No.
30 minutes?
No.
60 minutes?
no,
Did you drive the truck around to see if there was any exhaust that would come up into that space?
no, I did not.
Did you place a dozen bales of hay on top of this piece of plywood like Jake testified?
I did not.
Did you drive the truck around with these bales of hay to see if any of the hay came on?
No,
Did you put any bales of hay at all on top of this to see if that board would support the weight of a bale of hay?
I did not.
Do you know how much a bale of hay weighs?
Yes, I do. Depends on what kind of bale it is.
What are the ranges?
Well, you tell me which kind of bale are you asking about?
Well, you're
I'm
the one that
familiar
made,
with lots of different styles of bales of straw and hay, so
right, it could be 40 pounds, is that fair to say?
yes,
And if you have a dozen, that's at least 400 pounds. Did you find any tire tracks at scene 1 over Chris Senior's house that matched this truck?
did I? No,
Did anybody from BCI?
not that I'm aware of.
Did you have the volunteers go in feet first after the plywood was applied?
Yes,
Did you videotape it?
no,
Did you have them crawl out with a rifle or anything simulating a rifle?
no, we were instructed not to recreate using props.
Okay. Did you place someone 30 feet away from the truck, maybe towards 30 feet from the front of the truck to see if these volunteers could crawl out quietly without that person hearing?
No, I did not.
Would you agree that people carry their weight differently? some people are more muscular, and some people kind of have fat and are roly-poly. Would you agree with that?
Yes.
I'd like to move on to a different topic. You testified yesterday about the series of movies called Boondock Saints, is that right?
Yes.
You've watched those movies?
Yes.
Does either movie involve a mother figure who wrongly believes her granddaughter under the age of 2 has been sexually assaulted?
No.
Does either movie involve Facebook messages amongst people?
No.
Does either movie involve a jealous boyfriend whose ex just gave birth to another man's baby?
No.
Does any of the movies involve a character in there with a gun peeking under somebody's door before they killed him?
I don't think so. There's several scenes at doorways.
Does anybody in that have an SKS rifle that they use with an oil filter used as a silencer?
No.
Does anybody have a Glock that they use without a silencer?
Yes.
Does anybody have a 1911 with an oil filter used as a silencer?
No.
Does one of the brothers in the movie want to strangle his ex and frame her current boyfriend for the murder?
No.
Are there 2 pairs of cheap shoes bought to be used in any of the murders?
No.
Do either of the brothers burn all their clothing after the murder that was used?
There is a scene where they burn stuff, yes.
Is it clothing used in the murders?
I don't remember exactly what they burned, but it was after one of the murders, yes.
Do they cut up the firearms, put them in concrete, throw them in water?
No, they buried them.
They buried them. Was there a 9mm used in this case to kill any of the victims?
No.
Does the Norman Reedus character lie to his childhood friend and current pastor about the murders and many, many other people?
There's a scene with a minister, but I do not believe he confesses to any of the murders or lies about them. I don't think they're discussed in the scene.
Do any of the characters, does the Norman Reedus character in any of the movies laugh and smile and smirk about the murders while testifying in court?
No.
With respect to Boondock Saints 1, is it true that that movie involves 3 Russian mobsters going to an Irish bar on St. Patrick's Day in Boston, announcing they're taking over the land and they want to close the bar?
That's one of the first scenes, yes.
All right. And that these Russians are beat up and humiliated?
They ended up dead from that incident.
Right, because 2 of them sought revenge and the twin Irish brothers killed them in self-defense, right?
Well, that's what they alleged, yes.
All right. A lot like this case, right?
I don't think there was a self-defense ever mentioned in this case.
Exactly. And the media in those movies, in Boondock Saints 1, the media portrays these Irish twins as heroes, right?
Yes.
A lot like this case.
I don't think that was ever the case. They were portrayed as victims at one time by the media.
The police in the movie do not press any charges, correct? Against the twins, the Irish twins.
Correct.
And then after that, the 2 Irish twin boys decide to rid Boston of evil men, correct?
Yes.
And there's an FBI agent in that movie who decides to help the twin Irish brothers, right?
Yes.
A lot like this case, right?
No.
With respect to Boondock Saints 2, you watched that movie, right?
Yes.
In that movie, the scene is fast forwarded 8 years, correct? And the brothers are living a quiet life in Ireland, right?
Yes.
and they are drawn back into action when someone wants to attempt to frame the brothers for killing a priest in Boston. Isn't that right?
Correct.
And they take a container ship from Boston, a container ship to Boston, where on this ship they meet some Mexican man who's somehow involved in all this. Is that right?
Yes.
And the Mexican man had the 1911, not the brothers, right?
Yes.
And at one point, the Irish brothers kill a Chinese gang using a warehouse that processes heroin. Do you remember that?
Yes, where they hid in a container.
Yeah. Then the Irish twins kill a group of mobsters at a bar. You remember that?
Yes.
And there's a big shootout at some point with various mobsters and hoodlums. You remember that?
Which scene?
There's multiple scenes like that, right?
Yes.
All right. And the brothers eventually go to prison, right?
Yes.
All right. And there's protesters outside the prison demanding that the brothers go free, right?
Correct.
A lot like this case.
No.
Would you agree with me?
I said no.
All right, I want to show you what's been marked as Wagner Exhibit 50. Yeah. Sir, Wagner Exhibit 50. Take a moment if you could. See if you're familiar with that.
Yes, I am.
All right, I'd like to ask you some questions about that. So if you can keep that in front of you, that's fine. That, sir, what is that? What did you read?
Well, there's approximately 100 pages here, so, but at least on the top, it's the application and affidavit in support of an intercept warrant.
All right, this is the affidavit that was used by DCI to obtain the listening devices placed in the R&L trucks that you testified about yesterday. Is that right?
Sort of. That's not, we didn't obtain the devices through this warrant. We already had the devices. This is the permitting us to access the devices and listen to them.
Right. This was used to justify listening to the various conversations.
Yes, this is the order that allows us, that authorizes us to do that, yes.
Right. This is the information DCI provided to a judge.
But it does contain the affidavit, correct?
The affidavit.
Yes.
It's approximately 72 pages long.
It could be. I mean,
They're numbered at the bottom if you want to
Oh,
take them. And then there are some attachments at the end.
72 pages and then half a dozen attachments maybe.
Okay. Would you agree with me, sir, that this affidavit fairly summarized the investigation to this point in time?
Without reading it right now, I mean, yes, it should.
All right. And the date on the affidavit?
I didn't see the signature page, but the file date is May 24th.
Look at page 72, I believe.
Was that where the signature is
I
at?
believe so, 72 or 71.
72, it was signed by Special Agent Hageman on the 24th day of May 2018.
All right.
And then the
that's-
judge,
I'm sorry.
and then the judge signed it, yes.
And so on May 24th of 2018, that's approximately just short of 6 months before the arrest, right?
Yes,
All right. And on page 8 of that document that you have before you, DCI is telling the judge that over 500 interviews have been conducted during this investigation. Is that right?
that's what's listed, correct.
All right. Would you agree with that?
In that ballpark, yes.
Okay. And that over 40 search warrants have been executed?
Yes,
All right. over 100 subpoenas have been issued,
Yes,
and over 60 extractions of phones, DVRs, and other electronic devices, is that right?
yes,
And over 1,000 tips have been investigated by BCI, is that right?
correct.
And on page 9, there's information in there about the Montana interviews that have been conducted, is that right?
Give me a second to,
Take your time.
yes,
And that listening devices have been used out in Montana, right?
they have been. I'm not sure if it's on this page. Is it specifically on this page?
Can I look over your shoulder?
There's a lot to
There's
read
a
there.
lot of information, that's right. So let me try to help you out.
Yes, yes,
Okay. And that you had phone taps too, correct?
yes.
At this point in the investigation, you'd had phone taps.
Previous ones, correct, yes.
Yeah, previous phone taps.
Yes,
All right.
interceptions.
And on page 11, if you don't mind me looking over your shoulder, maybe I can point to this if you remember or if you need it. But in this, or on this page, BCI told the judge that all avenues of investigation had been exhausted. And that's why you needed this extraordinary measure of getting these listening devices placed in the R&I hearing trust. Paragraph 8, if you look at paragraph 8.
Yes, it says, exhausted all other avenues of investigation absent of unforeseen development.
So you guys have done all these interviews, done all this work, been testified for months now. And so at this point in time, what I call the traditional avenues of investigation have been exhausted. Is that fair to say?
Correct, that's one of the requirements when you apply for one of these.
Right, it's kind of a last ditch effort.
Yes, or explain that other investigative techniques would not work.
Right. And if you could go to page 17. Yeah, I can look over your shoulder to save a little time. If you could look right here where I'm pointing towards the top on April 22nd, would you agree that the BCI agent told the judge that there was that sufficient evidence had not been found to establish proof beyond a reasonable doubt?
Correct, at that time we had not. We had probable cause to arrest, but not enough at that time to proceed with prosecution.
And if you go to page 27, let me know when you get there.
I'm there.
Okay, let me look over your shoulder to save a little time. Very good. Give me a second there. All right, at the bottom of 27, and then it goes through page 45, so I'll ask you to look through here. But at the bottom of 27 through page 45, so that's about 18 pages, there's a lot of details about what is called the summary of details regarding the commission or attempts to commit the designated offenses. Would you agree with me looking at pages 27 through 45? There's an awful lot of information there, great detail about the investigation to them.
Yes,
And look through it because I want to ask you a couple of questions.
yes, it appears to be the affidavit with the probable cause statements.
Okay, I can look over your shoulder again. And you start off at the bottom of 27, talking about the victims and the homicides and where the victims were found. Is that right?
Yes,
And you go through on the next page, 28, and talk about the various victims and how many times they've been shot and where their bodies were found and the caliber of the bullets and the autopsies and different things like that. Is that fair to say?
yes,
Go to page 29, you talk about Jay Wagner a lot and the various Wagners, including Billy Wagner and phone records. And different things that have been testified about here in court. Is that right?
Yes.
And then that's page 29. If you go to page 30, it continues on with great detail about the various Wagners, including Angela and her buying the shoes up at Walmart and getting the pictures. All that information is in here, correct?
Yes.
Going to page 31, talk about a search warrant and finding the 22 caliber casings over on Peterson Road, how they were examined by personnel, and how they matched the crime scene 22s, and different information that's been testified here. Is that right?
Correct.
If you go to page 32, it continues on, some information about Jake and the purchases that he had made, the various websites concerning the weapons, that they're going to search warrant, and a lot of information has been testified to here in court, right?
Well, that's not exactly accurate. It says accounts belonging to Jake. It doesn't say that Jake made the
Thank you
purchases.
for correcting me. Counts belonging to Jake, right? Going to page 33, that continues about these alleged purchases, the drill bits, the Amazon orders.
Yes.
It has Jake's Chevy 1971 diesel, email account, detailed information that's been testified to here. Is that right?
Yes.
Page 34 continues on about past pro shop records, talks about the laptop, talks about phone calls that were made to order the signal jammer, right? Various things like that, right?
Yes.
At the bottom, it has two different photographs of Jake, correct?
Yes.
Purporting to show the different color of his hair, one darker than another, one longer than the other, right?
Yes.
The next page continues on with information obtained from Chris Newcomb and other people that have testified about the 40 Glock, about the brick house security records. That type of information is continued on page 35. Is that fair to say?
Yeah, it's Chris talking about George acquiring Glock handguns.
Sure. The brick house security down here that Angela used,
Yes.
the email address she used to make that purchase, right? A lot of information.
Right. George and Jake dyeing their hair. Yes.
Yeah, George and Jake dyed their hair up. So 36, it goes on and talking a little bit about firearms, laboratory examiner with the 22, and became aware it was a Colt 1911, right? Top there.
Sorry, I have to turn it. I can't.
Take your time.
Yes, this is about the 1911 22.
Right, and on this page, there are two photographs that the jury's been shown of the 1911 with Jake holding one of them, right?
Yes. With Jake's hand.
Jake's hand.
Yes.
Right. The jury's seen that, right?
Yes.
Okay. The next page, you get over to the Boondock Saints 2 clip. You have a little picture of that clip and it's described, right?
Yes.
All right. And then that goes on about what Billy told the investigators at different times.
Yes. And also about custody.
And about custody, all the information about that is in here as well, right?
The beginning of it is.
Beginning of it is. And if you go over to page 38, there's more information about what Jake told investigators about Hannah and different information about Jake, and that you had a confidential informant that could provide that information, different things like that.
Yes.
The next page, 39, there's more information here about Billy keeping firearms up at his bedroom at the Flying W, and the different interviews that were conducted after the Wagners went to the funerals, Facebook messages, different information like that.
Yes.
Page 40, the information continues on about what Angela told her, said about Billy and Chris, that they'd become friends through mutual associates, that she wasn't sure who killed the Rhoden family, and different information like that. Is that right?
Yes.
Page 41. You have the now infamous Facebook message between Hannah and Tess, which was talked about here quite often, right?
Right, the one that says, I won't sign papers. It won't happen. They will have to kill me first.
Yes, exactly, that one. That's right in here, right?
Yes.
And talk about these so-called guardian papers that were done, and beginning down here at the bottom about searching the laptop that was seized, right?
Yes, this paragraph's about the forged guardianship documents that Jake and George executed.
Right, and how Angela forged different names, right?
It doesn't say who forged them, but
Right, we now know she forged those.
she forged the signatures on them, but Jake and George forged the other part.
Okay, that's what you told him, right? And so page 42, it continues on about that, and then getting down to what Jake calling his grandmother, and there's a discussion there, right?
I know you skipped a paragraph, so I want to see what that's about.
Sure, take your time.
Yeah, this is, and again, I'm not reading it all, but this is a conversation Jake had with Rita about the signatures.
Sure.
Or the documents or something.
Sure. Page 43, up at the top, you have photos of George, right? With his Cummings tattoo that he later got covered up by the photo that was testified about yesterday with the skull, the 8-ball, the cards, and the dice. That's up here at the top, right?
The 3 aces, the 8-ball, and the dice with the 11 on it,
Right,
yes.
that's right here. And then just to the left of that is George with the Cummings tattoo.
Correct.
That he got covered up by this other tattoo.
Correct. And actually, I don't know where these dates come from, but
Right, but this is what was.
Yes,
written,
yes.
right? And there's other information here concerning the investigation. Right?
yes.
Going on to page 44, the information continues about Billy and Angela and Jake. How Jake called the investigators, wanting to know how he could retrieve his cell phone, other information that was about the investigation. Right?
Search warrant of the property owned by Jake and George.
Sure.
Jake asking about his phone, where they had lied about having jobs in Alaska. Where the Wagners had wanted to take their guns to the Rhodens in Virginia.
Right, that's their friends that live down in Virginia, right?
Yes,
And the Rhodens, the friends in Virginia, used to go up to Bethel Hill and hunt during hunting season, right?
correct.
Right, so those are friends of
Yes,
the Wagners, I'm sorry.
yes,
The Rhodens were friends of the Wagners.
correct.
Okay. And finally, over on page 45, kind of the top half here, it goes on about the investigation and how Caleb Sinarisky had called on the tip line and just as the investigation progressed.
Yeah, the shell casings being found in the driveway of Jake and George's property.
Sure.
Talking to Caleb Sinarisky,
Sure.
how they shipped packages to them.
Sure.
And then
And that's the topic, and then it gets into a different
Okay,
subject down
okay,
here.
okay,
Fair enough?
yes.
Skip over to page 52 if we could. This is this is additional information provided to the judge, right? And I'd ask you to take just a moment and read paragraph 25, and then there's an A below that, so just read 25
this?
to A. This is page 52 of the affidavit.
Okay,
Statement of other investigative procedures
Okay.
attempted or rejected,
All right.
which begins on 50.
I just wanted a reference of what I was looking at.
Of course. Take as much time as you need.
Okay.
So this statement of other investigative procedures attempted or rejected starts on 51,
Got it.
paragraph 22. I'm asking you to look at paragraph 25 on page 52. Take your time.
Okay,
Would you agree with me that that paragraph says that officers have determined that traditional methods will not produce sufficient evidence to prove guilt beyond a reasonable doubt?
correct.
If we could go to page 62. Just forward.
I don't want to fall, actually.
I don't want you to either. So let's turn to page 62. Yesterday, you testified, or at least you mentioned, about so-called provocative acts that would take place once these listening devices were placed inside the work truck. Is that right?
Yes.
All right. And what do you mean by provocative acts?
Again, it's just investigative activities that you do when you're up on an intercept warrant to stimulate conversation among the suspects.
All right, so if I understand this correctly, these listening devices were placed in the cab of this semi-truck that George and Jake are driving cross-country 5 days, right?
Yes,
All right, and in this truck, as is normal for these type of trucks, there's a sleeping area. Is that right?
yes,
Attached to it, it's part of the cab,
a bunk, yes,
a bunk. Right, there are bunk beds where one person can sleep while, or both people can sleep if they want, I suppose. But traditionally, one person sleeps or rests while the other person drives. That's not
correct.
And so, did your investigation in this case reveal that George and Jake basically spent 24/7 in that cab while they were doing their job for R&L?
Yeah, for the most part, yes,
Right? They weren't staying in hotels overnight or anything like that.
correct,
All right, this was a sleeper cab, right?
yes.
It had a refrigerator.
I don't recall a refrigerator in it.
Okay, well, you took photographs, but it was a living space, would you?
It's a sleeper,
It's a sleeper, so there's space in there
absolutely,
other than just the driver's seat and the passengers.
yes.
There's a curtain that can be drawn.
There's a divider, yes,
So there can be privacy back in the sleeper area,
Yes.
right? Okay, that's probably where Jake and Beth were, and they draw the curtain while George was driving.
I'm not going to infer anything about that.
Okay. Looking at page 62, if I could. Look over your shoulder again for foundation.
Come forward.
Yeah, I know, it's so big. I'd like to ask you about some of these provocative acts. So these provocative acts, correct me if I'm wrong, but you're trying to get them to say something so you can capture that on these listening devices.
Yes, we want them to discuss the investigation, correct?
Right. And you knew they had an attorney, is that right?
At this point, I'm not,
They had an attorney at this point?
on May 24th of
Right.
2018, I'm not sure at this exact point. I would have to go back and look at things for clarifications.
All right, well, you know who John Clark is,
Yes,
all right? And they had consulted with John Clark by phone
yes, at some point.
at some point.
Yes.
Okay, fair enough. If you don't remember, that's fine.
I don't remember the date and time frames. It's been a long time ago.
The records will reflect that, right?
Sure,
So one of the provocative acts that you did in order to get George and Jake to talk, so you could secretly capture that, is serving a court order on Rita to provide handwriting samples. Is that what it says there on page 62?
yes,
So you're using a court order to provoke them.
It's an investigative activity, yes. We do this in all kinds of investigations.
It's not unusual.
To do handwriting samples?
No, to use the court order to provoke somebody to say something they wouldn't normally say, but for your provocation.
If you're on an intercept, absolutely.
Okay.
It's a requirement.
It's a requirement. And you conducted a search going down the list here. This is paragraph 36, page 62. That was paragraph A.
Right.
Paragraph B, you conducted a search of the former residence in Alaska, and you said that or you told them that in a provocative act. Is that right? Is that what that means, or you explain?
I take it to mean a search was conducted at the Wagner's former residence. I don't remember or recall alerting them of that.
All right, at the top, 36, it says, the following provocative investigating acts are planned. Did that actually take place?
It did, and I believe the owner or the maintenance person is the one that notified them of the search.
Right, and that's what you wanted, right? You were hoping that the owner or whoever at that said, hey, your place just got searched, hoping to capture some conversation.
Yes, absolutely.
Kind of sneaky, isn't it?
Objection, I heard.
What was the question?
Kind of sneaky, isn't it?
I will sustain the objection.
You talked to Jake's former child custody attorney as a provocative act, right?
Yes,
Hoping that he would say something to Jake about BCI has been in touch.
yes,
You interviewed friends of the Wagners as a provocative act, hoping that would provoke conversation that you could capture.
yes,
And you talked to former church members and coworkers in Alaska doing the same thing, right?
yes. And I'm not sure about the church members, but yes.
All right, it says church.
I'm not sure if that was actually completed or not.
Understood. Okay. You conducted a search warrant in Ohio in a vehicle formerly owned by the Wagners to search for blood and other trace evidence, right? That was the plan anyway?
Yes, that was done.
That was actually done, right?
Yes,
You were hoping that the current owner might notify the Wagners of the search, right?
yes,
You wanted to conduct additional interviews, hoping that the people that you interviewed would contact them and once again capture something.
that's not what that says. It says identify frequent callers to the Wagners and then conduct interviews. So
All right,
if we identified additional, people that they frequently contact, we would interview those people.
right, hoping that they would say, hey, BCI came out and interviewed me,
Absolutely.
what's up?
Yep,
Served the court orders on the Wagners for handwriting samples to compare to Hannah Rhoden's signature on custody documents. You were hoping by serving those court orders, it would provoke conversation you could then capture.
correct.
Subpoena witnesses close to the Wagners to testify in the investigative grand jury, hoping that would provoke conversation.
Yes,
Make anonymous posts related to the case on public social media forums to be followed by Angelo, right?
yes,
Is that the topics that you mentioned yesterday?
yes, it is.
And are you the one that made those posts, or was it somebody else?
I made this post.
All right, and so you were posing as somebody else?
Yes.
Who were you posing as?
If you would provide me with the screenshots, because it's all documented, I could tell you the usernames. I don't remember the usernames from
That's fine. if you don't-
2018.
That's fine.
There
if
was
you don't-
numerous posts.
Numerous posts made by you
Yes.
under how many different names, approximately? You said more than one.
Honestly, it could be 5, could be 10, could have been 20. I don't remember.
All
I
right.
mean, that's a lot.
Okay, so you're on the computer providing real information on topics or fake information on topics?
No, so the information, sometimes there were searches that were taking place. So once those became public knowledge, I would comment on those.
You would comment on it.
Correct.
You would pose as somebody else and make comments hoping that Angela would see that. And then that would provoke conversation that you could then capture.
And it did, yes,
And it did.
yes. And then some of the ones, it was false information. So
You put false information.
Correct.
Is that legal?
Yes.
Is that ethical?
Yes.
It is ethical.
Yes.
Do you follow a certain code of ethics?
I'm not understanding why that would be unethical.
To lie and put false information on
There's
social
nothing that
media?
prohibits that.
Pardon me?
There's nothing that prohibits that.
You have no ethics that prohibit that?
Nothing.
No ethics at all.
Your Honor, objection. Asked and answered many times.
I'll withdraw the last one.
Well, I'm going to sustain the objection. I think the question has been answered 2 or 3 times.
I'll withdraw it, Judge. Thank you.
There's another question. Clearly, that's an acceptable investigative technique. I don't know if we need an instruction that it is acceptable since it has been raised, but that is something I'd ask the court to consider.
Well, you'll have an opportunity to read the rest concerning this.
Going to page 63, I believe you
Is this
all-
the continuing of the same subjects?
I
Okay.
believe so.
Okay.
Take a look
Yep.
there.
All right.
So at the bottom of 62 is small letter I, make anonymous post related to the case.
So that's the topic stuff, yes.
Yeah, to a public social media known to be followed by Angela.
Correct.
In the top of 63, little letter J, send anonymous messages to Jake's wife and/or others to include critical pieces of evidence. Is that what you did as well?
I don't remember that ever being done. That might have been a plan, but I did send the photograph of the 1911 to George. But I don't remember this actually ever occurring.
Okay, fair enough. Take that for just a moment. So at this point in the investigation, BCI did not have enough information to prove guilt beyond a reasonable doubt, and that's why you needed these listening devices. Fair enough?
Correct.
Just a few more questions, sir. I think you testified many times, right? I think you testified earlier in the case that you have lots of training, right, as part of, I mean, you're the lead investigator, you're very experienced, you have an awful lot of training in law enforcement, right?
Yes.
In fact, you teach other people as well.
Yeah, I teach at a basic, yes.
Yeah.
And then do some in-service training, yes.
Sure. Do you have any training concerning how to recognize behaviors that are consistent with mental health issues?
Yes,
You do?
yes.
What kind of training do you have?
We're required to take what we call crisis intervention training.
Okay,
So it's dealing with people that are in crisis, which is typically a mental health issue.
all right.
And actually, I was one of the first in Ohio to get certified that,
So that's a crisis situation?
which is typically mental health issues.
Of course. Could be a suicide, it could be holding someone hostage as a homicide. Is that accurate?
Sure, it'd be anybody that's in a crisis
All right,
and typically triggered by mental health episodes.
right. What about any training about chronic behaviors that are not necessarily a crisis, but chronic behaviors that are consistent with mental health? Do you have any training on that?
Yes, you would have to be more specific.
Well, do you recognize, have you had any training, I should say, on how to recognize paranoid behavior in someone over a long period of time?
Specifically in paranoid behavior, I mean, I've had training in all kinds of disorders, but, I would not consider myself an expert in any of those behaviors.
Right. I'm not asking if you're an expert. You're an investigator, you're law.
I can identify that somebody potentially could be in a crisis situation or a mental health state, correct?
Okay. And did you notice any red flags from Angela and her behavior as you investigated this?
No. First of all, red flag.
Well, yeah, I'm going to sustain the objection, at least to that form of the question, because I'm not sure that's self-defining.
Okay. Did you have any indications, based on your training, that Angela had any mental health problems?
I think that there's issues with 4 people that kill 8 people. Yes, I believe there's issues with all 4 of the Wagners.
All right, but did you recognize anything in particular about Angela? Not the murders themselves, but
Right.
leading up to them?
Again, I'm gonna interject. He's clearly not an expert in mental health. He's already stated that. I don't think he can render an opinion as to mental health.
I'm going to have to sustain that objection to that particular question.
That's fine, Judge. Have you had any training throughout the years in something called confirmation bias? Are you familiar with that term?
Sort of.
If I told you this, does this sound familiar? The confirmation bias includes where, in the law enforcement context, where there is 1, a focus on a suspect, 2, that the investigator selects and filter evidence that, quote, builds a case for conviction, while 3, ignoring evidence that points away from guilt. Does that sound like confirmation bias that you're familiar with?
I'm not, now that you've explained that, I'm not familiar with that term because
Okay.
it's not something I would do.
Sure. Are you familiar with the term belief persistence,
No.
where if new
No,
information,
object. He already said he's not familiar with it.
let me ask you this, I'll withdraw the question.
All right.
I'll withdraw the question. Let me ask you this. During the course of this investigation, let's frame it from the very first day until Jake gave his proffer in April of last year. There were certain themes developed by law enforcement as to why or how these terrible crimes took place. You would agree with that?
No.
You would not?
I would say that the investigation, the evidence that was recovered led us in certain directions.
Right, and certain themes were developed as to how you thought this went down or what was important, what was not important.
Based on the evidence that was
Based on the
collected.
evidence, right? For example, this hair dye that Jake talks about, or that you talk about, and when I say you, I mean BCI, not you personally necessarily, you're the lead investigator. For example, there was a lot of significance given at one point in time to the hair dye that Jake had and George allegedly had. Would you agree with that?
George did have his hair dyed.
There was some evidence to that,
There
right?
was evidence of that.
There was evidence, if believed.
I do believe it
I
because
understand.
I saw it.
I understand. But you later learned through Jake's proffer and testimony that the hair dye had nothing to do with the murders. You
That's
did
his
learn.
statement.
That's his statement. You don't believe that.
I do not. I think
Right,
he
that's-
minimized his brother's involvement.
There you go. So that didn't fit your theory before he gave you that information, so you're discounting.
I believe it's very suspicious.
All right, that's fine. You believed during the course of your investigation that custody over Sophie, as has been explained here, the custody issues over Sophie, between Jake and Hannah, was the motive to these murders. That's what you believed during the course of this investigation, up until the time that Jake and Angela made their proffers. Is that right?
And I still believe that.
And you still believe that in spite of the fact that both Jake and Angela testified here under oath in open court that it wasn't about custody, it was about the suspected sexual abuse. Isn't that right?
But they got custody to prevent the sexual abuse. So overall, it was about
That
custody.
doesn't, their testimony under oath doesn't fit your theory. So you're rejecting it. Isn't that right?
No, it does. It still was about custody of that child.
Can we approach?
Yes?
Thank you. Sir, there was a lot of testimony here about the Facebook message that you just read a portion of a little while ago concerning what Hannah said in that Facebook message, right? About, they'll have to kill me first. That
Yes.
message, you would call that. Do you have any evidence that Billy saw that message?
I can't remember if Angela ever disclosed that or not. I just can't remember.
But you would agree that it was Billy, according to Angela and Jake, it was Billy who decided to kill the victims.
Yes,
You would agree that all the victims were shot in the head?
with one being shot in the arm.
Right. Chris Sr. had other wounds, but all of the victims, including Chris Sr., were shot in the head. You would agree with that?
Correct.
Do you remember that green knife that was recovered from one of the concrete buckets?
Yes,
That belonged to Jake, right? He testified about that?
yes,
All right. And that was a zombie apocalypse knife? That's what it said on the side of it? Do you remember that?
yes,
And you sat here throughout all the testimony. You saw Jake smile and smirk during his testimony. Is that right?
yes,
And you would agree with me that there's absolutely zero evidence that little Sophie was ever sexually abused.
correct.
And that the only time George was interviewed was in Montana.
Yes,
And that you never seized his cell phone at any time.
correct.
Okay, just a moment. Thank you very much, sir. Thank you, Judge. I don't have any other questions.
Any redirect from the state?
Yes, Your Honor, thank you. Do you recall if Jake indicated whether it was straw or hay that he used in the back of that truck?
During his testimony or the proffer?
Either.
I don't remember on the testimony, and my memory of the proffer is he wasn't sure if it was hay or straw because I asked him about that.
Okay. And do they weigh the same?
No,
Tell us the difference.
straw would be the yellow material. It's usually lightweight, used for bedding. Hay is green. It's usually either like orchard grass or alfalfa or timothy, and it's heavier in weight, and it's used for feed.
Okay. You were asked if you videotaped the truck, the volunteers getting in and out. Did you observe them getting in and out?
Yes, I did.
Okay. And again, can you tell us how difficult or easy that was for them?
They had zero issues.
You were asked about a Glock being used in Boondock Saints, and you indicated that it was.
Correct.
And do you remember who used that?
It was in the second part. It was one of the final scenes. The father is carried up to the victim by his sons. He pulls out a Glock handgun and shoots his childhood friend at point blank range in the head with the Glock.
Is there also a scene where they drag bodies?
Yes,
And you were asked if a 9mm Beretta was used to commit the murders, these murders. And you indicated they were not, correct?
correct.
But obviously, can you tell us what role the 9mm Beretta did play in this case?
That was the original murder weapon, was to be a Beretta 9mm.
Overruled.
And as Jake had testified, that as he was test firing it with the suppressor on it, that there was a failure that resulted in the barrel being damaged.
Okay. The misfire of that maglite suppressor.
Correct.
Obviously, the Wagners are not, have not been celebrated as heroes, correct?
Correct.
But you're aware that they felt they were doing this to protect the vulnerable.
Correct.
You talked about a scene at a warehouse. You indicated that they hid in a container.
Yes.
And did they then jump out and surprise the victims?
Yes.
You were asked about the interception warrant application. First of all, you were not the affiant in that application, is that correct?
On that particular one, no.
Okay. But it contained a lot of the investigative information.
Yes.
Okay. At that point, had you confirmed the palm print for the picture of what you believe to be the hand of Jake holding the 1911 Colt, Walther Colt? In May of 2018, had you yet had the palm print match?
No, because we did not have a palm print to compare it to until we did the grand jury directive.
Okay.
There was no known prints for Jake Wagner on file.
Okay. And while you had seen purchases for parts to build a silencer, did you have the silencer out of the well at 260 Peterson Road in May of 2018?
No, we did not.
Similarly, did you have testimony or information interview of Beth Ann, the wife of Jake at that time?
Not in May.
Also, did you have any grand jury testimony at that time?
No, we did not.
Obviously, you did not have any information that you obtained from the interception warrant itself in May of 18.
Correct.
And had you had the shoe prints yet confirmed by an outside expert in May of 18?
No.
Additionally, did you have records from Text Now in May of 2018?
No, we did not.
You are aware that under the Ohio Revised Code, where you make application for an interception warrant, that you have to indicate, you have to provide a full and complete statement indicating whether other investigative procedures have been tried and have failed to produce the required evidence, or indicating the reason that other investigative procedures reasonably appear to be unlikely to succeed if tried, or to be too dangerous to employ in order to obtain evidence.
Correct.
That's required by the Ohio Revised Code.
Yes.
So you have to provide that information to the court.
Yes.
Okay. And what are some of the reasons why traditional investigative techniques would not work with this family of four?
Well, they're not going to talk about what they did outside of the family, right? They know what they did, so they don't have to discuss it with anyone outside. You know, they're a tight-knit group. They only trust certain individuals. You know, I think we had testimony that even the Newcombs, who were close to them, did not know that they had done this. So that's very difficult investigating this. Plus, they were planned murders.
Okay. Is it fair to say that a lot of times when you deal with co-defendants, they don't live together? And so if they're going to talk, they often have to talk.
Well, all right, yes, so the court will sustain that objection to the form of the question.
How common is it that your co-defendants live together, I guess?
Not very common.
You were asked about a series of what was referred to as provocative acts that you were doing. Again, does the same Ohio Revised Code statute require you to indicate to the court why you expect the conversations related to the offense will occur?
Yes, you have to provide an explanation of why you think you will capture the conversations from the suspects.
Is that the same as when you go into a home, you have to establish for the court why you believe the object you're looking for or the weapon you're looking for in the lake would be found in the lake?
Yes,
And you are specifically not permitted to listen to conversations that aren't relevant, correct?
correct.
Now, regarding some of these investigative techniques that you listed that you felt would provoke conversation amongst the Wagners, were those investigative techniques that you were going to do whether or not you were up on an interception warrant?
Some of them would have been yes.
Okay, so for instance, the subpoena to get handwriting of both Rita and Angela in this case, is that something you would have done regardless?
Yes,
Okay. And specifically, why did you want their handwriting?
because we believe those documents to be forged because we had pulled known signatures from Hannah Rhoden and they did not match.
Okay.
And the date at the bottom of the forms clearly demonstrates that they were backdated forms.
Okay. And same thing with wanting to get the fingerprints and palm prints of each of the Wagners.
That would have occurred.
Okay. Same with the interviews that you did of their known, you said you knew who they talked to the most and you interviewed those people. Would those be people you would be interested in interviewing regardless?
Yes, we would interview any family members or new or old associates of the Wagner family as we became aware of them.
You were asked about posting information that was not true on the social media, correct?
Yes,
And you indicated that you personally had done that.
yes,
Okay. And for instance, I believe you testified in your direct that you talked about a search warrant that had not occurred, or a search warrant that was going to occur that actually was not.
yeah, I don't think it was a search warrant, it was a search.
Okay. And you indicated that that was an acceptable interview technique, correct? Or I guess,
Investigative
is that
Yes,
an acceptable interview technique?
investigative technique, yes.
Okay. When you are interviewing a defendant, for instance, are you allowed to say things that aren't true to them?
Yes,
And in this case, you were investigating the homicide of 8 persons, and you believe these 4 individuals to be responsible at that time, correct?
correct.
You were asked if you knew that George had an attorney at that time, and you were asked if you knew who John Clark was. Did you know who John Clark was representing at that time?
I don't believe we knew exactly at that time of the application for the intercept.
Okay. And can you tell us what your understanding is as to whether one attorney can represent more than one criminal defendant.
Basis is. Yes.
What was your understanding at the time as to who John Clark was representing?
In May of 18, I'm not exactly sure, but I know there was knowledge of Angela making contact with him. And there was discussion about Rita. I'm not sure who else.
Okay. And you were asked if there was proof beyond a reasonable doubt at the time you made the application, or the time that that application was made. Did everybody on the team feel that way at that time in May of 2018?
Yes, I think we all were in agreement that we had probable cause to arrest them, that we wanted to make sure that we had all the evidence necessary to convict each and every one of them.
Okay. And you were asked about basically getting tunnel vision in this case and just going with, you thought these people did it, so that's the only pieces of evidence that you looked at. Can you tell us how many people you ruled out in this case?
Dozens.
And I think you testified earlier something about the normal progression of a funnel. If you could just tell us that again.
Yeah, most of the time in most investigations that I've experienced, you start out, you're made aware of your crime and you quickly develop suspects, based on information that you're seeing or by witnesses. In this case, it went exact opposite. There was just more and more people brought in to the equation. And we looked at those people. We ruled everybody out. We were very careful to make sure that we got the correct people.
And had the evidence not corroborated your theory regarding the Wagners, would you have used the evidence to rule them out instead of ruling them in?
Absolutely.
You indicated that you saw that George had dyed his hair, correct?
Yes.
Where and how did you see that?
There was a post on Facebook of him, I believe it was in the pasture or yard of Peterson Road. And there was testimony about it.
And You were asked if you're aware whether or not Angela showed Billy the Facebook conversation that Hannah had with Tabitha's mother regarding she would not sign papers ever, and they would have to kill her. Do you recall Angela saying that she showed the other three that message?
Yes.
And additionally, do you recall Jake explaining his habit of smiling at, I think he said, inappropriate times?
Yes, he made an apology or some sort on the stand.
And you were asked if you ever seized George's phone. At the time that you stopped them at the border in Montana in May of 2017, did you know if that was the same phone that he owned at the time of the homicides or if it was a different phone?
It was a different device.
Had it been the same device, would you have seized it?
In Montana, yes.
I have no other questions, Your Honor.
Any further cross?
Just a few questions. So you're saying you don't know if it was actual straw or hay that was put on the top of this truck, right?
Correct.
All right, did you try putting straw on it?
I believe I already testified no.
All right, well, you testified you didn't put hay on it either, right?
Okay, I don't know what you asked me, but I didn't put either.
You didn't put either, I guess that's my point. And it's your testimony that as a law enforcement officer, you are allowed to lie to a suspect or to the public about an investigation, is that right?
Yes,
All right. And an ordinary person, though, is not allowed to lie to you about an investigation, is that right?
they're not allowed to obstruct an investigation.
That's right, and they're not allowed to give.
They can lie to me all they want as long as they don't obstruct an investigation.
But they're not allowed to give false information to police officers, that's a crime, right?
Not in itself, it's not.
It's-
Only if it's relevant to an investigation.
Right, and relevance is determined by law enforcement, right?
It's determine whether or not it obstructs an investigation.
Right, but in general, let's talk in general. When you say something's relevant, when I say you, I mean as a law enforcement officer or someone investigating the case, that person decides what is relevant.
I mean, it could be yes.
I have no other questions. Thank you, sir.
Council approaches. You may step down.
Thank you, Your Honor.
Ladies and gentlemen, the court wants to give you a cautionary instruction. Now, yesterday you saw some still pictures and heard some testimony concerning a movie entitled Boondock Saints, and also concerning a sequel to that movie, which was referred to as Boondock Saints 2. And you also heard some testimony today concerning that movie and that sequel to the movie. Now, the purpose of this evidence introduced by the state of Ohio was the state's attempt to show similarities between the plot of the movie and the state's evidence in the present case. Now movies are made by actors, and the plot of a movie is often the product of someone's imagination. You must consider only the evidence in this case, and you must weigh that evidence. In order to do that, you must consider whether there is evidence that the defendant was familiar with the movie Boondock Saints and the sequel Boondock Saints 2, and whether the plot of either of those movies reflects the facts of this case as established by the evidence. If you find that the evidence does not support a finding that the defendant was familiar with either of those movies, or that the facts of this case as you find them from the evidence are not shown to be similar or sufficiently similar to the plot of the movies as testified to, then you are to disregard the photographs presented yesterday and the testimony concerning the movie or the sequel to that movie. Does counsel have anything further you wish to suggest?
One second. Three questions.
Yes. Needs to go over some things which do not involve the jury in this case. So we're going to have an extended break, which you may use a portion of as much as you desire, I guess, to get lunch and so forth. But we will be in recess until 1 o'clock this afternoon. So you've got a good bit of time. We're basically extending this morning break into the lunch break too, and we'll be coming back here. You'll be coming back at 1 o'clock to the jury room downstairs, from where you will be brought back to the court, back to the courtroom here by court personnel. While you are on break, you're not to discuss this case among yourselves or with anyone else. You're not to permit this case to be discussed with you or in your presence by anyone. You're not to form or express an opinion concerning this case. You're not to do any research concerning the case, either as to the facts or as to the law. You're not to read, view, or listen to any reports or accounts of this case from any source at all, and you're to have no contact with participants in the case, including parties, counsel, or witnesses. Now, does counsel for either side have anything further that you wish to put on the record before we recess as far as the jury is concerned until 1 o'clock? Anything further from the state before we release the jury? Then we are in recess until 1 o'clock. Leave your notepads, of course, on your seats. And at 1 o'clock, assemble at the jury room downstairs to be brought up to the court. right. Do we want to do anything on the record right now, or was council going to go over some things? It's my understanding that, that the next matter that we were going into was some portions of some recordings and transcripts with regard to those. Is that where we are with this?
Yes, Your Honor.
And I had suggested, I believe when this was discussed on, it was Friday, that council exchange these transcripts and the defense counsel, because these were presented to them. I'm not sure if it was on Friday or at any time before Friday, but at least my understanding is that a totality of the recordings had been given to defense counsel some time ago, and possibly even the transcripts, but that it had not been indicated until perhaps on Friday, Thursday or Friday, what the exact portions of those recordings that the state intended to attempt to introduce, and therefore the transcripts of those portions. And so I wanted defense counsel to have some time to go over those. I think they did go over some of them on Friday and possibly over the weekend. But what I had hoped was that that the accuracy of the transcripts could be gone into, and then any inaccuracies or dissimilar things could be pointed out to the court specifically. The only alternative to that would be for the court to listen to all of the snippets and view them myself against the transcripts, which I can do, but I have not had the recording, so I have not been able to do that. So I don't know whether council has done that, going over all the recordings and the transcripts.
Judge, thank you. On Friday, and I believe you, Mr. Nash, I did go through all the transcripts and recordings that were provided to us Friday morning. Appreciate the opportunity to do that. There are some we have objections to. There are many we do not. So I think we need to go through the ones that may be in dispute. Either because of the quality of the recording, or perhaps there's a portion of the recording that should be played. The state may not agree with. But just when we were at sidebar, we were informed that there are additional transcripts and recordings that they intend to provide us today, I guess. I'm not sure what that is.
Is there some reason why these could not have been provided before today, the day that they intend to play them?
Well, again, Your Honor, so yes, it's called, we've been in trial for a long time, and there's only so many hours in the day, and 2 and 3 hours of sleep at night is already taxing enough. But, they've had these recordings since 2019, and then we also provided them they wanted to know any calls that we felt were pertinent, we provided that as well. And then with a little short summary of what each call was about, BCI investigation or Beth Ann or whatever, just some little snippet. And then they asked us for transcripts, and we did provide them transcripts. These transcripts in particular are 412 pages long. I know that because I also, went through those because there were some that weren't included that I knew existed that I wanted to include. So I also spent the weekend going through that. So, our analyst has been working on trimming down the video or the audios and all that stuff. So it's just a matter of time consuming, Your Honor.
Okay, I think on Friday, at the end of the day, after council, I guess it was the state's council had the opportunity to go through these. And one of the, I think, objections generally has been, and the court understands why, is any summaries being included or anything cleaned up by saying this was what was meant, and those kind of parentheticals in these, which really then makes them not exactly accurate transcripts at that point because of the additions or corrections. So there was problems of that kind, and I think the state went through these on Friday and I clean up is the correct word, clean those up. I was handed at the end of the day, I believe, 26 transcripts. Now, does that sound accurate? And I think the first of which was, I believe, dated May 31, 2018. The last of which was dated August 25th, 2018. And I think there were 26 of them. Does that sound accurate for what the defense had? I do notice that what counsel for the defenses has on his has those introductory statements or on which I think have been removed from the ones that I received at the end of the day.
So we met with the defense attorneys at the end of the day, gave them a clean copy of just the Word documents.
As I have.
And it began.
Identical.
Identical copies.
And I have, and it looked like there were 26 of them.
I got
25?
But I think there was maybe something for just text.
Just text. That's right. So I thought my final count was 28, but I'll go back and recount.
28?
Yes, sir.
All right.
But
Judge, with respect to what was given to us on Friday, we obviously are prepared to explain which ones we agree with, which ones we don't. One of my concerns is, are they doing this today?
I don't know how yours were organized. I tried to go through these and organize them chronologically. I don't know if that's,
And that's the way it will be presented, Your Honor, and I apologize, when that got printed off, the computer orders them by the number, right? So if there's a 100, it's gonna come before 700, you can call 700 even though chronologically it would be different. So, but the way we have it organized to present is chronologically.
and some are dated the same day, but they're two separate transcripts, two different times, which I guess we could call, for example, I don't have one in front of me right now with two dates. Yes, I do. It looks like May 31st, for example. We could say May 31st, transcript 1, May 31st, transcript 2, or something like that in chronological order. Does counsel want to go down through what you understand you're going to be presented and go over it with defense counsel? You can have my copy too, to make sure I have an accurate copy. And then, and so that when we go through these, it seems like, unless we're ready to do it now, but there's been some additions, is my understanding.
Yes, we need to provide those to them, so, and to ourselves.
So do you want to,
So if you want us to do that right now, I'm sure that they're ready now.
yeah.
And provide
Yeah.
that.
If you would do that, and then you can go through mine too and make sure I have an accurate, and then organize them in chronological order so that your stack, the defense stack, and my stack all have all the transcripts in chronological order.
Yep.
And we can go down through them, see which ones are objected to. All right.
How many new ones do we have?
I don't know. I'll let you know momentarily, I didn't count.
All right. So we can go off the record now, what counsel does that. Let me also say, I don't, maybe this should be on the record too. Let me also say that one of the things that's going to come up is this problem. The instruction, cautionary instruction to the jury will of course tell them that the evidence is the recording, not the transcript. So then the question arises, if the evidence is not the transcript, is the transcript an exhibit for the jury to have? It sounds like maybe it is not. It sounds like it is not to me. If it's not the evidence, then the transcript is a listening aid. I think the case law supports it's a listening aid only. So then the question becomes, how does the reporter deal with this?
So Your Honor, here's what I have prepared for the transcripts that we turned over on Friday. We made copies, we made 17 copies of each transcript for the jury. And the intent, I think, for the court of written would be when each recording was played, we hand the jurors their copy. When that recording was done, we take that copy back, we mark one, submit it for record, but not necessarily fact. That was the intent of the plan that we wanted to run by the court.
Presented for the record, but it would not be, it is not the evidence, is my understanding.
Correct.
Judge, with respect to that, many of these recordings are really very clear.
Okay, so you don't need a listening aid.
So there's no need for this. There are some that are not clear at all. And we can argue whether listening aid is appropriate or not, or whether they're just such a poor quality, they should be played at all. But, you know, for the ones that are clear, and we say it's probably important.
The only issue that I have is it clear given the acoustics of our audio setup here? So I mean, that's something, well, that's a bridge I guess we'll have to cross.
But, well, and let's do one other thing here. If you present one for the record's sake, it's not evidence, so it doesn't go to the jury. Is that correct? I mean, they have it, well, as a listening aid, but if they have it in the jury room, then they're going to be looking at it as a piece of evidence. And
I think the concept is, obviously, they can listen to it now, understand the testimony recording with use of the aid. Once it goes back to the jury, they would have a recording to play back as
Only
many times as they
recording,
needed. They can sit around a speaker if they needed to. But I think that's the not necessarily.
it's not evidence. So, all right. Okay. So here's my copy of these, and somebody
Thank you.
take one.